Good morning. It is Sunday, March 15th, 2026, and this is Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Hello, everybody. Welcome. Thank you so much for waking up on a Sunday morning to join us. Little Miss Red Velvet and Jenny G and Jonna Moore, Becky B, Kathy Mama Bear, Shy Gal. So good to see so many of you. Good morning, Josh, our main man, and she is Juice. Good to see you as well. Hello to everybody in the chat. Hello to everybody watching on X, everybody watching on Facebook. If you are watching over there, please say hi. Send us a little chat. Tell us where you're from. We'd love to hear from you. We'd love to know that we're not just speaking to an empty room over there. To everybody who is returning, welcome back. Thank you so much. You are part of the wonderful crew that makes Sunday Fun Day so special, and we always love to see you. And to everybody who is new here, welcome. I think you're really going to enjoy this. A lot of really great questions this week. You guys came through yet once again, and let me introduce myself to the new folks. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I was there for just over 10 years before I left to go into private practice as a criminal defense attorney. We started this channel, Courtroom Confidential, with the idea of presenting to you both sides of the courtroom, both sides of the issues, and both sides of the stories. And we hope that we do that. And this is a show that we do every Sunday morning called Sunday Fun Day, where we take your questions that you've left us throughout the week, voicemails, and we're going to answer them live this morning. This show, I'm just going to warn you, I'm going to keep it tight. I have a little bit of a time crunch because right after this, I'm going to go join Joe Giacalone on True Crime with the Sarge. So we'll put the link in the chat, but that's going to happen. We're going to finish this around in 2 hours from now, hopefully, and I will be joining him right after that. So I'm going to tone down the bloviating. That's what I'm going to do. I'm going to just kind of keep it a little brief. Stay to the end, though. We do have announcements, some fun stuff I want you guys to hear about. But take a deep breath. You've made it. It's Sunday, everybody. It's the beginning of a new week or the end of an old one, depending on how you look at it. Take a deep breath. Hit that like button if you haven't already. Subscribe, please, if you haven't already. Bethy Ann has been a member for 10 months, everybody. She says, good morning. Share this with anybody that you think might enjoy it. But Chihuahua Mama, member for 9 months. Wow, almost as long as it takes to make a baby. I love this community. And Annalie Finch, thank you for kicking us off this morning. She says, juiced for more great questions from our CC fam. Yes, we are all juiced. I don't see any percentages, though. We're going to have to get those going. I would like to know exactly how juiced everyone happens to be this morning. All right. Let me see. I think I've got it all set up. Fingers crossed. Kitty Kitty Meow says, we thrive on your bloviating. I appreciate that. All right. Who's the first one up here?
Hi, Josh. This is Mary. I'm calling from Carthage, North Carolina. First time caller. I got a question. I was just listening to this week's Sunday Fun Day, and I had a question on the Colin Gray. Do you think prosecutors are looking at these charges where they charge a parent for the child shooting up a school? Do you think they're looking at it like, I'm not sure it's in every jurisdiction. I think it's maybe New York where they, let's say someone goes in and robs a store and they kill someone. The person, the getaway driver is charged with murder, even though they're not holding the gun. They're not the actual one that shot them. Do you think that's along the same lines that they're looking at this at? Just had that question. Thanks. Bye.
Mary, first-time caller. I love that. Love for first-time callers. Glad that you joined us. Glad that you worked up the courage to ask a question, and it's a great question. So let's put Carthage, North Carolina on the map. Mary is asking about Colin Gray. A lot of people are very curious about this case and how were they able to charge this person. We've got more than one question about this one today. So I'm glad that you started out with this. This, to me, is one of those cases where I'm going to be thinking about for a while from a lawyer's perspective, because there are a lot of legal issues attendant here. I understand why people are upset. I understand what people are beyond offended by his conduct. There was another school shooting. It looks like something could have been done about it. It looks like this parent, had he just been a little bit more attentive and a little bit more involved, and a little bit more reasonable, we would have avoided these 4 deaths. But instead he didn't. And now these 4 beautiful people are dead. His son's going to prison for the rest of his life, most likely. Lives are ruined across the board. And so I get it. But how did we arrive here from a legal perspective? So Mary is asking, is this like cases where you see the getaway driver being hooked for the murder at a bank robbery gone bad, an armed robbery gone bad? And what you're describing, Mary, is what's called the felony murder rule. And that's the idea that if you are a participant in a felony and that felony ends up resulting in murder, you can be on the hook for first-degree murder, and the people involved in that can also be on the hook for murder. So is that what we're looking at in this case? No, not exactly. This case is different. And the reason why, well, first of all, it wouldn't apply to this case because when you're dealing with a felony murder type of liability, it has to involve a violent underlying crime. Usually those are enumerated in the statute. Things like the R word, things like robbery, things like other assaults, kidnappings. When those result in somebody dying, then we're going to assume intent, assume premeditation, and put somebody on the hook for first-degree murder and the others involved in that crime, even if they're not the one holding the trigger, even if they're just the person participating in it. Not here, because the crimes, the underlying crimes that they could have charged him with are things like child neglect, improper storage of a weapon, things like that, because he didn't actually participate in the shooting. And that's the part that has me most bothered, and a lot of people bothered. He didn't hand his son the gun that morning. He didn't drive his son to school and say, go do what you know you need to do. He had no idea. Colt Gray was an independent actor, yet we're holding Colin Gray, his father, responsible for the murders. Now, how did they get there? It's under a theory of second-degree murder called implied malice murder. So malice is what you need for murder, and you can get there by either actual malice, demonstrated malice, somebody who's doing something that it's obvious that their intent is to commit murder, or implied malice, things like conscious disregard. And that's what they charged him here. The theory was that he had a conscious disregard for the consequences of his actions, that they might lead to, they had a reasonable likelihood of leading to great injury or death. They're saying you knew that your son was very troubled. You knew that your son had access to weapons. You gave your son access to weapons. You were warned about your son's violent proclivities. Your son had pictures of school shooters on the wall, sir, and you didn't do anything about it. And when even your wife told you, hey, by the way, other parents, the Crumbleys, got charged in crimes like this, maybe you should secure those weapons, he said. And I think the reply was something like, it'll probably cause him to be more angry than he already is. Bad all the way around. Second-degree murder? Implied malice murder? I don't know. That's really kind of stretching the envelope there, really kind of stretching the boundaries of what we consider for murder. So excellent question, Mary. I'm glad that you're thinking that way. And thank you so much for kicking us off this morning with a wonderful question from Carthage, North Carolina. Debbie Harrow, you are so amazing and generous, and we appreciate your support. She says, super duper excited, super duper CC crew. Join. Listen to Debbie, everybody. I don't know why you're not listening to Debbie. She's saying the right things. Go ahead and join our crew. Go ahead and subscribe if you haven't already. Arizona Gal, thank you so much for your support. Hello from Tucson. It's spring break here, and yes, even attorneys watch YouTube. Armchair sleuths are among the brightest. We rock. I agree with that. Everything that you said. And I might be, who knows when I might be back in Tucson. Anytime, I'm just waiting for news to break there. And I'll be back in Tucson, I'm sure. And Marie Jubinville has been a member for 10 months. Everybody, golf clap for Marie. Good morning, Josh. Good morning, right back at you. All right. Where are we off to next?
Hi, Joshua and the amazing Courtroom Confidential team. First-time caller here, Lori Robin Wilson from Port Ludlow, Washington, also known as a village in the woods by the bay. here on the gorgeous Olympic Peninsula. Two-part question. I just finished reading the prosecution's 122-page response to Rex Heuermann's defense's omnibus. Number one, what is an omnibus in this context? Number two, because it seems from this document, the prosecution really has a lot of evidence and has shot down the defense quite strongly. If Rex takes a plea in the face of all this, do you think New York will insist he tells them all about these 7 murders? Or will he get a Brian Kohberger sweet deal? Thanks in advance for your answer. I'm 100% juiced, and I love the new t-shirt for CrimeCon.
Oh,
well done.
Love that. Yeah, we got a new CrimeCon t-shirt. Whip it up, Kaylin. Find it. First of all, let's put Lori from Port Ludlow, Washington on the map. First time. Wait a minute. Did I read that right? Yeah. 2 first-time callers in a row. Good Lord. What a great morning. What a great Sunday. Port Ludlow, Washington. First-time caller. Thank you so much, Lori. There's the shirt that she was talking about. We're very, very happy to announce this. I was going to talk about it later, but Lori, why not? This is a new exclusive shirt we're going to have for CrimeCon. Shout out to Kaylin for designing it. She's incredible. She does everything, folks. And no, you can't have her contact information. She's staying with us. This shirt we are going to start selling for everybody, for all of our members starting April 1st. It's going to become available to you because somebody brought up the wise idea that, hey, if you only sell it at CrimeCon, then we can't be wearing it when we show up to CrimeCon. We thought, yeah, that's actually makes sense. So April 1st, to everybody who's a member, you can buy this shirt. We're very excited about it. I think it's very cool. I can't imagine other people having shirts like this. Let's keep it rolling, it says on it. Get it, everybody? All right. Quit bloviating, Ritter. Back to Lori's question. Rex Heuermann. First of all, what is an omnibus? An omnibus, I actually like this concept. In some jurisdictions, the judge says, listen, whatever you got to say it all at once. I'm not doing this thing where every time we come back to court, you guys file another motion and there's another evidentiary issue. And every time we come back to court, we got to schedule arguments and have responsive documents. Because every time the defense files something, the prosecution is going to go, hey, Your Honor, I need time to respond to that. Then the judge is going to give them a briefing schedule. Then they might not need a day to argue it. Then the judge may need time to actually decide on it. Tyler Robinson, anybody? These things can drag on. Well, in some jurisdictions, or maybe just per judge, I'm not sure if this is an actual rule in New York, they file it by omnibus, meaning put it all together at once. Tell me every single issue you've got in this case. Discovery, evidence, where you want the cameras placed, whatever it is, we're putting it all into one motion. Then the prosecution's going to respond to everything, and then we're going to come to court, and that might take a few days, and we're going to talk about everything. So that is what an omnibus is in this sense. I like it. I think that more jurisdictions should do it. It might move things along. And then to your next question about, it looks like the evidence against him is very strong. It's incredibly strong. They've got his DNA. They've got his blueprint. Good grief. You want to talk about stuff that'll give you nightmares. They've got, what else do they got? They've got digital evidence that tracks him having these secret accounts and emails under an alias where he's kind of setting up these meetings with these young women. They've got him many different ways. It's a very strong case. If you want to learn more about it, come to think of it, we actually did a case file. Not sure which one. Case notes, I think. Case file on this. Case notes on this. We'll put the link in the chat. So we kind of covered this. We might be updating it. Anyhow, will they insist upon a proffer plea if he takes a plea? I don't think there's any way he's taking a plea. And here's why. There's no death penalty in New York. So what he's looking at is a life without parole 7 times over. What are they going to offer him? What is he? First of all, Kohberger, great that you brought that up. Kohberger wanted to avoid the death penalty. So there was something there to negotiate. I know a lot of people were upset with the way that ended, but that's the way that ended because they have the death penalty on the books. If they did it, he probably would not have pled. But he wanted to avoid the death penalty. That's the only thing he wanted to avoid, was the possibility of the death penalty in Idaho. So he said, if you take that off the table, I'll go ahead and plead. They can't do that here. There's no death penalty in New York. So what are they going to offer him? We'll have you plead to only, 6 life sentences or 2 life sentences, 1 life sentence. What does it matter to him? Unless they're going to give him something with the opportunity of getting out of prison one day, which they're never going to do, he's got no reason to plead. Why not take your chances when the best that you're looking at is already what they're probably going to offer you? Go ahead and take your chance. Maybe the government messes up. Maybe they have problems with their witnesses. Maybe they have problems with their evidence. Maybe there's some huge long shot that you get a win out of this whole thing. I don't think at all, but that's what he's thinking, and that's what his lawyers are thinking. So I would be completely beyond shocked if this thing ended up in a plea deal, because there's no way. And he can't go to the judge and say, Your Honor, the prosecution won't give me a deal. Can you give me a deal? He can't change anything. So the judge will say, yeah, you can plead guilty to 7 first-degree murders, and you're looking at life on every single one of them. So I don't know what you want me to do. So it's probably going to go to trial. But great question. Lori, first-time caller from Port Ludlow, Washington. Unless he doesn't want all the publicity, says Crystal. That's true, too. But I take it that this guy might be the type to be enjoying all of this. All right, where are we going to next here? Let me make sure. Calm down. All right, here we go.
Hey, Josh, Tiff, and TC fam. It's Nell from Michigan calling back with another off-the-wall question for you. I've been watching that show Lincoln Lawyer on Netflix, and I've actually been surprised at how many of the scenarios and issues come up are similar to what we see in real trials. Some of the same things, actually, even though obviously there's a fictional aspect and the timing is a little bit fake and unrealistic. Anyhow, but there was something that did come up that I wondered if is actually a thing, and it was actually with the jury selection. So first off, the defendant was part of the jury selection. He was like telling the lawyer who he did or didn't want on the jury. And then as things kind of play out, he ends up like tampering with the jury, trying to like get somebody to not testify or make sure the person he wants is on the jury. Anyhow, this may be a dumb question that I should have learned in high school, but since you've become my actual education on how our justice system works, I have to ask. First off, does the defendant have a right to participate in jury selection, just like they have a right to be a part of the trial itself? And then also, if so, has there ever been a case that you're aware of where the defendant is tied to some sort of jury tampering? Would love to hear your thoughts.
Nell from Michigan. Thank you so much for calling in. Always great to hear from you. This is a great question. Both of them. I love it. First of all, Lincoln Lawyer. It is a good show. It's on Netflix. I do enjoy it. It is, they've got it. They kind of figured it out. There is a realness to it. There's also an absolute ridiculousness to it, just from a lawyer's perspective. But I think they kind of get it about as close as most shows do. But to your first question, do defendants have a right to participate in jury selection? Absolutely, they do. And oftentimes they will participate. Oftentimes they won't. Sometimes, defendants are just kind of sitting there and they're listening to everything and they're letting it up to their lawyers. Maybe they got a team of lawyers. Maybe they've even got a jury selection consultant working on the case. It depends. I've worked under all sorts of conditions, and I've worked with all sorts of different clients who some are taking notes and very involved and giving their input, and others just kind of sitting there and letting it all play out and letting the lawyers decide because they're the experts at doing this. Just a quick side note on jury selection experts. They always kind of bothered me because as a prosecutor, I had picked dozens upon dozens of juries, and then they want to hire this outside person to come in and tell us, what their kind of armchair philosophy is on where juror number 3 was looking when they were asked a question. And some of it just became a little, I don't know why I went on this tangent. Some of them bothered me. Some of them are very good, but some of them bothered me. Anyhow, but of course they're allowed to testify or participate in it. It's their jury. Many times, if a client wants to participate, I let them. I don't want to be the one to be like, no. You want me to kick juror number 3? I like juror number 3. I'm going to keep juror number 3. And then what if things don't go well? Then they're looking at me and going, why'd we leave juror number 3 on there? They're the ones going off to prison if this all goes sideways. So if they want to be a participant in their own destiny and decide who sits on their jury or not, God bless. I am not going to stand in the way of that. I'll give them my advice and insights, but if they are an active participant, I am not going to stand in the way with that. This is their destiny on the line here. This is their life on the line. If they want to help pick the jury, have at it, good sir. And have I ever been aware of jury tampering? Okay, I'm going to tell you a quick story. I don't know if I shared this story on one of our members only lives that we do every month. If I haven't, though, I'll give you a quick teaser right now and then remind me, and I'll do it at our next members only live. But there was a case back in 2009 when I was still a law clerk, actually, in the DA's office. The prosecution of a man by the name of Anand John, and that's spelled A-N-A-N-D, and then his last name was John, J-O-N. He was a fashion designer, kind of famous, kind of an up-and-coming hip new fashion designer. And what he was doing is he was luring all these young women. And this was, by the way, kind of before the real exploitation of online predators that we see nowadays. We're going back to 2009, nearly 20 years ago. But he was finding these women. I think he was putting advertisements up on Craigslist or something like that, looking for young models. He would fly them out to LA, young women, early 20s, late teens, tell them how beautiful they are. I'm going to take some photographs. And then the photographs would, why don't you go ahead and lose that? And, oh, come on, you're an adult, and go ahead and take that off. And before you know it, they're undressed, and then he's sexually assaulting him. And so he got charged with several counts of the R word, and ends up getting convicted and going away to prison for, I think, the rest of his life. I'm not sure how many years. So during this trial, though, and I have a very funny story about this. And again, I don't want to be a tease, but I want to save it. So I'll save it for the next members only live. But remind me and I'll tell you a very funny story about how I helped out on this trial as a young law clerk. But during this, his sister would come to court every day. Her name was Sanjana. You can see her there, kind of very attractive younger woman, would come in, very fashionable, kind of always dressed up. She started flirting with one of the jurors. Now, the juror was very reciprocating in this flirting. So I'm not going to try to make it sound like she is completely, only to blame. This juror was very involved in this mutual kind of flirtation. He asked for her number. Somehow he was able to contact her. She gave him his number. They were texting. He wanted to meet her. He even told her that he would help with the jury. He tried to hang the jury on the case. She finally came forward to law enforcement. Law enforcement wired her up and set up a sting operation and caught this juror. So in the middle, I think it was jury deliberation. I might be wrong on that. They did a sting operation and arrested this juror. He, of course, got removed from the case. The defense lost their minds, thought that this was a complete, blah, 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 due process, Fourth Amendment, whatever, everything. The judge said, no, I'm removing this juror and I'm allowing the rest of the jurors. It doesn't look like they were involved in this or that his tampering extended to them. It only extended to his vote. I'm going to allow them to deliberate. They did deliberate and he was convicted, like I said. So crazy story. But yeah, it does happen. Not very often at all. Very, very rare. I just happened to work on a case that involved it. So there you go. You've been doing this long enough and you got some stories. Thank you so much, Nell from Michigan, for asking the question. Heather Cooper Smith with the super sticker. Thank you so much. That's so kind of you. This is Leslie B. Oh, thank you so much for gifting the Courtroom Confidential memberships. Appreciate you, Leslie. That's very, very kind of you. Leslie B again with the super chat. Curious, if you don't mind sharing, how much do law clerks usually get paid? Is this during law school? It is during law school, and they make the fabulous salary of $0 per week, and they get that per week, 52 weeks out of the year. But that all being said, when I was a law clerk, there was a position that existed at the time for a paid law clerk, and I was a paid law clerk. I made, I don't know what I made, $20 an hour. I don't know. It wasn't a lot of money. They eliminated that program after I left. They might have brought it back, but I think they eliminated it. But the answer is the vast majority of law clerks are not getting paid. Sometimes they're getting school credit, but most of the time it's kind of like a program where you just have an in and you're meeting people, getting experience, and you want to move from that into becoming a DA. This was back in the day, by the way, when becoming a DA in Los Angeles was incredibly competitive. When I applied, they would open up a class of hiring of, say, like 20 people, and they would have like 1,500 applicants for those 20 spots. I don't think that's the same way it is anymore, but it used to be a place where a lot of people were very competitive to work at it. But thank you, Leslie B. I don't know. In other counties, they may have paid positions, but not in LA, I don't think anymore. All right, where are we going? Keep it moving, Ritter. Keep it rolling, Ritter.
Hi, this is Karin from Sweden. I have a purely procedural question about the school shooter dad, Colin Gray. During his trial, his son was kind of presumed guilty, even though he hasn't gone to trial yet. So why was the dad on trial first? Shouldn't the son first have been found guilty as a prerequisite to the dad's liability, so to speak? And what happens? How can the son still be presumed innocent now? And when the son actually goes to trial, what if he's acquitted? Can the dad's trial then stand? I mean, I don't understand. Can you please untangle that web for me? Thanks, everyone. Bye.
Karen, I'm saying it all wrong. Karin from Sweden. Thank you so much. First of all, let's put Sweden on the map. Incredible that we have listeners over there. Karin is the official president of our Swedish Courtroom Confidential fan club. Great questions too. These are exactly the questions that I'm talking about. Why people are so kind of bothered by this case. Again, no one is bothered by the fact that we're doing something about school shooters. No one is bothered by the fact that this guy got charged with some kind of crime. Where we're bothered, or where we have questions, or where we're scratching our head, as Karen says, is when it comes to things like, wait a minute, for the purposes of his trial, we're assuming that the other person, the actual trigger person, the actual shooter, did the thing they did, and they haven't even been put on trial yet. How does that work? Well, you're right. They are kind of just assuming the truth of the underlying crime. That crime has not been proven. Now, that part, I can kind of wrap my head around. You can understand how they don't have the elements of proving that underlying crime. They just have the elements of proving that he allowed for the commission of that underlying crime. Still, I get it. I can still hear you asking the question, well, they still have to prove that underlying crime. They didn't have to prove it here, though. They didn't have to prove it beyond a reasonable doubt here, because it's not a charged crime. That's what's interesting, is the murder committed by the son is not a charged crime. It's just the actual deaths did occur, and did he do things or fail to do things, meaning Colin, that led to those deaths? Even as I speak this out, even as I talk this out, it becomes more and more confusing. Okay, then let's get to the question of, why did they do it this way? I don't know why they did it this way. I think that the son's case is just far more complex and serious and going to take much more time. And I think that was it. But now, does this affect the presumption of innocence for the son. No, it doesn't. So you're going to have the son go to trial, presuming that he is innocent of the crime charged, that his dad was already convicted for facilitating, essentially. Is that going to be explained to the jury? Likely no. Are they going to understand that the father provided him with a weapon, that the father didn't get him to proper therapy, didn't take the weapon away? They're probably going to be told those facts just so they understand how he got the weapon. But the idea that the father was convicted is really not relevant to whether or not he's guilty for having committed the shooting. Again, starts to really hurt your brain when you think it through. And then what if, in the unlikely scenario, he's acquitted? What if Colt is acquitted? Now do we have these completely unacceptable verdicts? The answer is the law would see it as no. They're charged with different crimes. People can be found guilty or not guilty depending on the evidence surrounding their individual crime. So you could have, it's not going to happen. I would be absolutely shocked. I'll come back here and I'll eat our brand new Courtroom Confidential t-shirt in front of you all if that happens. But if this guy is acquitted flat out, I would be absolutely shocked. But you could, and it would stand, and the law would allow for him to be convicted or acquitted and his father to be convicted. And wouldn't that be outrageous? And here's the thing. We've seen cases before where different levels of involvement, like you said, that somebody brought up earlier about the you've got the getaway driver and you've got the actual shooter inside of the bank. There are cases where those verdicts don't entirely line up. Maybe the getaway driver gets convicted, and maybe for whatever reason, the inside job guy doesn't get convicted. But we've accepted all of that because we understand the theories involved in people who are mutually participating, though at varying degrees of culpability in a crime. Here, the part that I keep on coming back to is that kid is an independent actor. That kid made up his own mind. That kid decided to go get that gun and not tell his father and hide it in a backpack and take it to school and commit the nightmarish act that he did, all without involving his dad. Yet we found his dad guilty for murder, not neglect, not child abuse, not any of those things. Murder. Let's see what he gets sentenced to. I mean, there's another question. How much time does this guy get? Does he get murder type time in prison? That's what he's looking at. Great question, Karen. I know I'm butchering your name and I'm sorry, from Sweden. All right. I said I wouldn't bloviate, but here I go. Debbie, you are amazing this morning, Debbie. Thank you so much. Mods. You deserve a break. Coffee, tea, wine, whatever you desire. Snacks to share with the super duper Josh and beautiful Tiff. They are used to mac and cheese and chicken fingers. I remember what Josh says. I think that's exactly the dinner we had last night. Wasn't it mac and cheese and chicken nuggets? Tiffany's nodding yes. Yes, we did it. Mommy and Daddy, I think, had leftovers of something else, but the girls had mac and cheese, chicken fingers, and there was something else. Oh, zucchini. They had zucchini, which is nice. They are always good about eating their vegetables. Debbie, you're so amazing. Thank you so much for your generosity and support. And Annalie Finch, thank you. Coffee and tea donations for our fabulous mods. That's very, very kind of you, Annalise Fitch. And Julia Miller just gifted a membership, everybody. So thank you to Julia, whoever received that. All right. Let's keep it rolling. Where am I going? Here we go. No, wait a minute. What am I doing? I'm already lost. Here we go.
Hi, Joshua. It's Jim from the Marshall Islands again. I have a question that I've been kind of struggling with lately. You hear over and over again that motive doesn't matter, the state doesn't have to prove motive. And yet, I'm watching Kouri Richins, and the state's case seems to be 100% motive or 90% motive. I mean, if it's not something you have to prove, if it's not one of the elements of the crime, why is it even allowed? Why are they even allowed to talk about motive if it's not something that you have to prove? And some of these cases just seem to rely on almost nothing but motive. Thank you. Love your shows. Watch you all the time. Bye-bye.
Jim, one of my dudes from the Marshall Islands. I love this. Can you zoom out again? I always forget. Look at that. Middle of the ocean. That's the internet, folks. Look at this. Look at all those dots. Pan over to the right a little bit. Still South America. I don't know what's going on there. We can't break the. We got to check our internet provider. Does YouTube provide to South America? We got to get it translated. That's what I got to do. Anyhow, Jim, thank you so much for all your support for heading up our South Pacific Courtroom Confidential fan club with a great question too. Motive. I say this all the time. Motive doesn't need to be proved, but it's very important. But if it doesn't need to be proven, if it's not an element of the crime, Jim says, then why are we hearing about it? Why are we talking about it? And why are they relying so heavily upon it? Well, just because it's not an element doesn't mean it's not relevant. And that came out a lot more catchy than I intended it to be. But just because it's not an element doesn't mean it's not relevant. What is required to be proven is intent. Okay? Intent is the purpose behind one's actions. Intent is, I committed this act with the purpose of killing this person. I had an intent to commit murder. I had a purpose of taking that person's life. Motive is why. Why did I do it? Well, I did it because I wanted money. I did it because I wanted to be with my new boyfriend. I did it because I felt like my husband was holding me back from this real estate empire that I was going to. My husband was holding me back from this real estate empire that I was going to build. The reason why we don't require motive is a prosecutor has a lot to prove and a lot that they need to explain to jurors, but explaining what is taking place between someone's two ears is seen as too much. But it's still relevant, and it still helps move the ball forward, and it still helps jurors understand that, yes, this person likely committed that crime. Because if they've got a motive to commit it, if they've got a reason, a why to commit it, then it's more likely that they did commit it. Same works the other way. If they had no motive, they had no reason, you can be sure the defense is going to exploit that and say, why in the world would this person commit it? So they're relevant questions, but it's just as far as making an element and a burden upon the people that they have to prove beyond a reasonable doubt. The law says, no, you have to prove the purpose, the intent, but not the why, the motive. But great question, Jim. I'm glad you asked it. I love that. I loved making that distinction for everybody. Dagny and me, thank you so much for supporting our mods with coffees. I think I pronounced that right. And Susan Riley, thank you for the super chat, says, Josh, I love that you start with take a deep breath. You made it. Aside from my comedy pods, you are my favorite pod to listen to in my pharmacy. Super juiced in Virginia. You are greatly appreciated. Oh, I love that. I love that you're listening to it while you work. And I love that I made it along with the other comedy pods. And Heather Cooper Smith just gifted a membership, everybody. Thank you so much, Heather Cooper Smith. I'm juiced this morning. I'm happy. This is a good morning. All right. Where are we off to? Let's figure it out.
Okay, this is my very first time, and I'm hoping you will even be able to hear Dagny in the background. Yes, it's Dagny and me, formerly Marta Fonda, and I hope this hasn't been asked before because I've listened to Sunday Funday as often as I can. My question is, when there is a sidebar and the witness stays in the courtroom, can the witness hear what's being discussed? And if they can, you can hear Dagny in the background commenting. If they can it affect things, or is that a concern for either side for an appellate thing down the road somehow? Anyway, happy Sunday Fun Day. I hope this hasn't already been covered, and if has, then I'm just saying good morning, everybody. Oh, Diamond Point, Washington, which is between Port Townsend and Squim.
Marta or Dagny and me. What incredible timing, right? We did not plan that out. So thank you so much, Marta or Dagny and me. I love that name for a dog. I'm guessing that's your dog's name, Dagny. I love that name. From Diamond Point, Washington. Let's put you on the map. And a first-time caller. I love this. What a great, I don't know, synergy. Thank you, Marta, for calling in, and thank you for being a first-time caller, and thank you for helping out the mods with coffees. And a great question, too. This is great. This is so funny because this does happen. Marta asks, what if there's a sidebar and the witness can hear what's being discussed? And I'm going to add to that, what if the jury can hear what's being discussed? So sometimes sidebars will take place in the back, in judges' chambers. The judge will say, okay, everybody in the back. I've had judges do that. I've also had judges who just have you go off to the side, and then you kind of all huddle in the corner, and you've got a little microphone there so that the stenographer can still take everything down, and you're all kind of in hushed tones. And what's always so funny to me is the judge will say, we're going to have a sidebar. Go ahead and, discuss them, feel free to talk amongst yourselves. And you go off to the sidebar, and all 12 of them are like dead silent, and they're all staring at you across the room because they're all trying to pick up on what you might be whispering. It's like that. It's that thing when you say, don't pay attention to X, everybody's paying attention to X. I imagine the witness is probably doing a little bit of that too. And sometimes voices become raised. I mean, I can't imagine in a quiet courtroom when you're sometimes not all that far away from the jury or the witness, and attorneys are over there starting to have a little bit of a heated back and forth, that they can't hear it. And I've had situations where judges tell us to kind of quiet it down. I had a situation where we would always go into the back hallway. And in the back hallway, even though it's right up against to where the jurors were at. And one time we were really going at it in the back hallway. And when we came back out, they let us know they could hear what we were talking about in the hallway. So to your question, though, what kind of issues might that create? I have never experienced that becoming an issue on appeal. I've never experienced where a judge has had to instruct jurors to ignore what they may have heard. But that's a very interesting question, because sometimes they are discussing things that are important, things that the jurors shouldn't know about, evidentiary issues that have been kept out, and that's what's being discussed. Has the door been opened? Has it not been opened? Am I allowed to ask about this conviction that this person has that you won't let me talk about, but I feel the door's been open, and we might be referencing things. In fact, many times that's what a sidebar is all about, because we can't have that discussion in open court. So we're having a sidebar, and it usually does involve stuff that the jurors, for whatever reason, we don't want them knowing about at that time. I don't know. I've never even had a judge ask the jurors if they heard anything. So I think we all just kind of go under this assumption that our whispered voices are good enough. And I've never seen it become an issue. I'll try to look into it though, but I love the question. And it is funny to me how we just kind of I'm sure they're picking up on half of this. But anyhow, Marta, first time caller from Diamond Point, Washington. Appreciate you. Gamer Mom 740. I got it. Everybody's yelling at me. I would think something about supplying a weapon would make more sense than to charge the father with the deaths. They've done it in the past, where they've charged them with the supplying of the weapon. And by the way, if we're opening up this door, you can imagine, listen, there are plenty of young people who commit crimes of violence that don't involve school shootings. There are plenty of young people that go out and commit murders that don't make the headlines because it's not school shootings. Are we going to start charging every single parent who may have been aware of their wayward son or daughter, who may have been aware that they were running with the wrong people, had access to weapons, didn't do enough about it? It's a very slippery slope. But thank you, Gamer Mom 740 for that. Allie Foley says, I still eat chicken nuggets and mac and cheese for dinner, and I'm 43. Well, that's because it's nutritious and it's comfort food. And thank you for that, Allie. And it's also easy to prepare. Best Nancy, thank you so much for gifting the Courtroom Confidential memberships. Appreciate you and your support. Let's keep it rolling here. Where am I? All right, here we go. Oh, come on. Okay, here we go.
Hi, Josh, Tiff, Kaylin, best mods ever, and fantastic CC crew. This is Best Nancy from Newport Beach, California, calling with a question that actually stumped Josh last weekend, but I bet he knows the answer now. With the popularity of Aaron Spencer, since he just won his primary and basically everyone loves him, is it possible for the prosecution to ask for a change of venue, given their most likely unpopular stance against him? Anyway, that's my question. I hope everyone has a great Sunday fun day. Bye.
Best Nancy from Orange County, California. Are you guys doing this on purpose with the timing of the people? This has worked out perfectly. Thank you, Best Nancy, for your support, and thank you for asking a question. And yes, I think I did tell you, ask me this question next time. This one is still an interesting one to me. We were talking about Aaron Spencer. There he is. Look at that guy. Just won I think it was the Republican primary for sheriff. So I don't think he's been elected sheriff yet, but he's one step closer. And he's still being prosecuted for murder. So that's interesting. And I had said, if that's any indication that he won the primary, that might not be all that friendly of a jury pool to the prosecution. And then that became the question of, could the prosecution ask for a change of venue? And I wasn't sure. So sometimes what I'll do, I'm in a group chat. There he is, my boy and his turkeys. Always makes me happy. I'll ask the group. I'm in a group chat of all of us were prosecutors. Most of us are former prosecutors, and one of the folks on the group chat is currently a prosecutor. And we will talk crap with each other and tease each other about sports and politics and everything else. And every once in a while, a legal question will come up. So I asked them all of this, and they were all stumped too. And I'm like, how come all of you seem to be experts on everything until it comes to what you actually do for a living? So they looked it up. I looked it up. The answer we came to is, of course, first of all, it depends, I think, per jurisdiction. But at least in California, the answer is there's nothing preventing the prosecution from doing that. There is not something specific to the law that only the defense can ask for a change of venue. And in fact, I think a good example of where this has happened in the past is, if you remember the case of Jeffrey Ferguson, who was the judge from Orange County here in California, who was charged with murder, and he was a sitting judge in Orange County. They moved that, not upon the defense request, but not necessarily upon the prosecution request. They moved it because the entire Orange County judicial panel essentially said they had a conflict in the case because they were sitting on the same bench as this person. So they moved the entire prosecution up to Los Angeles County to be heard in front of a Los Angeles judge, but it was still the Orange County prosecutor's office. I bring that up because that's the closest example I can see where a venue can be changed to a different county and you still keep the same prosecutor's office. So that was where I was curious, is how do you move the prosecutor's office? Well, you just do. The answer is, yeah, I'm going to say yes, you can do it. The prosecution is the one originally determining venue, by the way, by where they charge someone. But if along the way they feel that pretrial publicity, bias, political atmosphere, for whatever reason, the people as a party to this legal action are not going to get a fair shake, I don't see anything preventing them from asking for a change of venue. They haven't done that in Aaron Spencer's case. It would be pretty incredible if they did. I don't think that they will, because I think more than anything, then it'll really look like they're trying to railroad this guy, and it already appears to be that way. So you imagine if they said, well, we feel like we can't get a conviction here, so we're going to try to go somewhere else where we could get a conviction. Then it looks like you're just gunning for that person. I mean, this thing should just get settled. They should give him, if they want to charge him with some sort of negligent discharge of a firearm or something like that, let him move on with his life. I don't know. I don't. This is becoming more and more of an embarrassment to that county and that prosecutor's office. Even the appellate court had to remove the judge. The whole thing's becoming a mess, and we will follow it closely because it's one that kind of I know is something that a lot of you are concerned with, and I'm certainly concerned with. All right, let's keep it rolling now. Eroy, thank you so much for gifting the memberships. Appreciate you, Eroy. Good to see you. Zarcasm has been a member for 10 months, everybody. Y'all make things better even on my worst days. Oh, well, thank you. I hope you're having a good day today, though. Ms. Annie K has been a member for 8 months, everybody. Hey, CC Pals, thanks to Josh, Tiff, Mods, and she is juiced, everybody. All right. Hold on. I got it.
Good morning, Joshua, Tiffany, Mods, the whole Courtroom Confidential family. This is Lori Feeney calling from Bolivar, Ohio, with a question about case law. Okay, please explain, if you could, how a judicial decision becomes case law. Does every decision become case law once it's made? Thinking of the most recent school shooting where Colin Gray's father was found guilty of murder, will that become case law now moving forward and set a precedent? On a side topic, it also is a slippery slope that these kinds of verdicts can start, which you've talked about. So I'm wondering too, if the Gray decision becomes case law, can it be used then to hold parents responsible for deaths that their children cause in other ways, such as supplying alcohol for teens? Maybe parents might be required to keep their alcohol under lock and key sometimes. I just don't know. There's so many possible repercussions. My main question, though, is about how does something become case law? So I will be quiet now and listen to your answer. Thank you so very much for all you do.
Lori from Bolivar, Ohio. Let's put you on the map. Always great to hear from you. I love this question. This is great. I love the questions where it's something where I kind of take for granted that we all know what we're talking about, and maybe we don't. And it's an opportunity to explain this and understand it for everyone. And it also makes me think about stuff that I just kind of might take for granted too. So what is case law? Lori wants to know, will the Colin Gray decision become case law? First of all, it's helpful to understand how our legal system works. When we call something laws, that can mean a couple of different things. One, laws are statutes, something passed by the legislative branch. They all get together, they pass a law, they say, hey, we think that killing another person should be illegal. Therefore, we're going to pass a law. We're going to make it part of the penal code. It's a statute. And we're going to say that murder is the unlawful taking of another person's life with malice aforethought, and that's murder. And we've got it in the books now. Don't do that. Then we go from case to case to case that says, well, what does that mean? What does the word unlawful mean in that context? What does malice mean in that context? What does aforethought mean in that context? What is another human being? Yes, all of these things have been asked. What is the context of these things? What does it mean in the law? And the way that you get there is you have a case, someone gets convicted, and then they appeal on that issue. And they say, hey, we don't think the government proved malice. They proved X, Y, and Z. We don't believe that that's malice. Define for us, judges. Now it's in the judicial branch. Define for us, judges on the appellate level, what is malice. So, and that creates case law. Then that creates, as you refer to it, as precedent. Then we refer to the case of People versus Gray for its what it stood, what the court meant by the word malice. Okay. So what he's been convicted of is not considered a decision. It's a verdict. Once Colin Gray appeals this, and he's going to, the appellate court there in Georgia will have an opinion, and that opinion will become case law. That opinion might be based on other case law. So we might not refer back to the case of Gray all that much because they're referring to another bigger case. But if the case of People versus Gray says something new, breaks new ground, which this case likely will, then people may refer to the Gray case later on, according to Georgia versus Gray, Your Honor, X, Y, and Z. And then that creates precedent moving forward. Then maybe they appeal that up from the Georgia appellate court to the Georgia Supreme Court or to the U.S. Supreme Court. And each level that it goes up, it creates precedent on a wider range of jurisdictions. So the appellate court would only really be controlling in their appellate division. The Supreme Court of Georgia would include all state cases in the state of Georgia. You appeal it up to the Supreme Court, and now it applies to the entire country, where it creates precedent in controlling law. I hope all of that makes sense. This case itself is not going to create precedent. No one is going to be charging someone based upon or referring to People versus Gray as to why they're doing X, Y, and Z. But once this gets appealed, and once there's an opinion, an appellate court, Supreme Court opinion, that opinion becomes case law, or what we refer to as case law. Great question, Lori. Hope that made sense to everybody. Hope I didn't confuse everybody even further. Little Miss Red Velvet, LMRV, says, best channel, best mods, best chat. I love it here. Cheers. Member for 6 months. Love it. Love right back at you, LMRV. Redondo Beach, good to see you. Has been a member for 11 months, everybody. 2 times meniscus tear here. I need entertainment. Oh, my. Well, I hope that entertainment doesn't involve any kind of dancing. So sit tight, and I'll try to keep it entertaining for you. All right. Let's keep it rolling. Where am I going? Where am I going? Here we go. Not my fault, Kaylin.
Hi, Josh. My name is Jen, and I'm calling from Bellevue, Washington. The defense in the Kouri Richins trial just rested without calling a single witness. And that really surprised me and made me kind of wonder, why they would do that, what the strategy is there, and do you have to balance what the jury might think about that regarding, whether a person is guilty or innocent. And so I'm curious, how often does that happen, that a defendant will not call any witnesses, and what is the strategy there?
Jen from Bellevue, Washington. Thank you so much, Jen. Good to hear from you. Wow, that's the Washington contingent showing up today. I appreciate that. Asking about Kouri Richins. A lot of people were curious about this. I will say today too, guys, you had a lot of questions. A lot of people asked questions. I wasn't able, we just don't have the time to get to all of them. Please don't be offended or bothered if I wasn't able to get to your question this time around. It kills me. It's like hurting a little part of me every time I say I can't answer that question. So please ask again next week if I wasn't able to get to your question this week. But like I said, I'm under a little bit of a time crunch, and you guys did ask a lot of kind of similar questions. So I tried to pick one that at least addressed the thing that you were curious about. But Jen was one of many people who asked about Kouri Richins, and specifically about the defense and the idea that they didn't call any witnesses. And is that a problem? Is that a strategy? How will the jury perceive that? Well, one of the things I always say is don't write checks you can't cash. If you are in opening statements and you are telling people, as the defense, we're going to prove this, and we're going to show that, and you're going to hear this, and a witness is going to say that, and you don't do any of that, you write all those big checks and you don't cash them, that's a problem. That's why most defense attorneys are they rein it in a little bit in opening statements. It's more about keep an open mind. Everything that you hear from the prosecution, they're going to have to prove to you. They have not proven that to you. Wait till we have our opportunity to cross-examine these witnesses. Wait till the very end, blah, 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 blah. But, you got a situation like Brian Walsh where they're describing to you how he found his wife and what he did and why he didn't call police and why he acted the way he did. And then you call no witnesses or you don't put him on the stand. That is writing a very big check that you didn't cash. Jurors remember that stuff. Here in this case, I think they did a little of that. I can't remember anything that I felt was like, oh boy, how are they going to prove that one? It was more about, and I think they have followed through to some extent through their cross-examination of a lot of the promises that they made to the jury in opening statements. I don't believe did anything in opening statements where it made it sound like Kouri's definitely going to testify. But it was a little surprising when we got to the end and they didn't have any witnesses. Now, how will the jury react to that? Well, they might subconsciously go, oh, wow. I thought we were going to hear more from the defense. But sometimes in fact, most times, it's not a strategy decision by the defense. It's a reality decision. Are you going to call witnesses if you've got nobody to call? Who are they going to call? Are they going to call her friends? No. The friends got called, by the way. They all took the stand against her. They going to call the boyfriend? I don't think so. We heard a lot of talk about earlier. They said they were going to call their own witnesses because those people are testifying now. Well, it sounds like they felt like they accomplished what they wanted to accomplish with those witnesses on cross-examination. So that whole complaint didn't really come through. But a lot of it has to do with, are we really going to call witnesses that are helpful to us? Because we've seen situations. Oh, boy. I'm blanking on the case now. Oh, I'm so bad about this. What was the one just recently, the au pair? Banfield, right? Banfield, where he called witnesses that were not entirely helpful, right? If you don't call, you got to think about that too. Sometimes calling a witness just to call a witness, it's not a scoreboard here, how many witnesses were called. And if you call a bad witness and it backfires on you, bad on you, right? So it could be about limiting damage. It may be the defense in Kouri's case are going, hey, we've got it about as good as we're going to get here. We risk hurting ourselves far more than we might benefit from calling anybody. And it could be that they just got nobody, right? I've heard people say, well, why don't they call a drug expert? Why are you going to call a drug expert when you're not contending how the person died? They're not saying he didn't die from an overdose of fentanyl. They're saying, yeah, he did. We just didn't do it. My client didn't do it. Either he did it to himself or somebody else did it to him, but it wasn't her. So what is that expert going to get you? These are the things that they think about. And I think more than anything, you get to the end and you kind of go, okay, we have a far more chance of making this worse than we do of making it better. Let's just rest right now and get to closing arguments. And I think that might have been the decision more than anything here. But, the jurors are instructed not to hold it against them, but who knows how subconsciously they just might. But great question, Jen from Bellevue. All right. Kathy Mama Bear. Oh, yes. Happy Mother's Day to our UK mums. We love you. That is very true. It is Mother's Day in the UK. Happy Mother's Day to all the mamas in England and around the world, by the way. All right. Christopher II, thank you for the super chat, says, in Kouri's trial, what happens with the defense's direct examination of Ali now that they rested without presenting a case in chief? Forgot to call. Yeah, that's I think the thing I was referencing isn't that where they made the whole hullabaloo about wanting to, whether or not they needed to recall people. I think they just thought to themselves, you know, a lot of times too, you see how a witness is not entirely friendly to you. They're certainly not going to be helpful to you if you have to call them and do a direct examination of them, and then give an unfriendly witness up to cross-examination by the prosecution that they're friendly to is going to have a field day with that. So I think that might be what's at play here. And Mix Firebird's child, Nashay, has been a member for 9 months, everybody, considering applying to paralegal studies program despite being over 40. Thoughts? Love it. Here's my thoughts. It's going to take you how long to do that program? 2-3 years? 2-3 years is coming whether you like it or not, Nashay. And in 2-3 years, you could be considering becoming a paralegal, or you could be a paralegal. So go do it. That's my thoughts on that. All right. All right. That got Tiffany juiced. All right. Get it together, Ritter. Where are we going? Here we go.
Happy Sunday Fun Day to you, Josh, and my CC virtual friends. This is Martha, aka Mama of 3, from Gaylord, Michigan, where I am currently getting buried in snow and freezing rain again. My question is not really about any particular trial, but it has to do with the state and defense attorneys. Do you have people in your offices who watch while the trials are live and keep track of what the live streaming chat members are asking, commenting on, and saying, I wish they would ask this, or I wish they would ask that, blah, blah, blah? Because the chat could potentially be in the same mindset as the jurors that you're trying to convince for your side to either convict or acquit. If so, do the chatters help you key in on points you need to mention in your closing arguments to make it all of your evidence crystal clear? Thanks for taking my question. And as soon as Sunday Fun Day is done, I'll be heading out with my shovel. Bye, y'all.
Martha from Gaylord, Michigan. I hope you're staying warm. I know, is the storm, Kaylin was saying she was getting hit by a storm. Is that storm still going on? You guys getting just buried in snow? Oh boy. All right. Well, I hope everybody, all our friends out in the Midwest and the Rust Belt there are staying warm and having some hot cocoa. Martha, thank you so much. Love this question. Love this question. The answer is all of this kind of YouTube following of trials really kicked off since the time that I've been a prosecutor. I know I'm still a defense attorney, but not nearly as heavy a trial practice. And I have not personally confronted this, but I think it's a great, fascinating turn in how trials are being conducted. And it does seem like attorneys are becoming much more savvy, especially in these high profile cases, these cases that are being streamed, that they're keeping an eye on it. I mean, we've heard more than one reference. What case was it? Oh God. The Black Swan. Wasn't there an issue in that case where a juror had somebody put on a chat something about having contacted a juror? Wasn't that, am I remembering that correctly? There was something to do with that. But I think you're going to see that far more often. I do believe that that they are paying attention. Do they have somebody like actually sitting in an office watching a stream and watching the comments to try to pull away information from that? Maybe. I mean, if they've got enough, the juror had a phone. That was it. It was Benefield. Was that her name? Yeah. If they've got enough resources, you can imagine them doing it, right? Who knows? I do know in sometimes you get these large corporate litigations and they've just got money to burn. And I do know that there have been situations where in these large corporate litigations that they have streamed it to a test jury who is watching it to give them feedback, live feedback on it. But now you're talking about using the entire YouTube chat as feedback. The problem I would say with that, maybe it's helpful for things like how an attorney is being perceived. We certainly saw that. Everybody seems to think that, is it Ramos in Kouri Richins' trial, that he really had a change of demeanor? That could have been absolutely from the way that he was perceived online. But you have to remember the people online are getting all of that information that the jurors aren't getting. They've got all the background information. They've already kind of come into this with preconceived ideas and biases many times. They know about the evidence that's not being presented. They've heard the arguments that are outside of the presence of the jury. So that's probably not that helpful of a test jury than it might be. It might be a test jury that might be skewed because they know more information than they should, or that the jurors know. So that's where I would be careful. But we live in a fascinating time for these high profile trials. I'm sure they've got people who are taking a look at it, at least taking the pulse of it. They've certainly got, I mean, in Tyler Robinson, they were complaining about people trying to lip read their clients. So somebody somewhere is giving them feedback on these things. Great question, Martha, from Gaylord, Michigan. Jadzia Dax says Kouri's defense got in their direct examination of Ali during the state's case, then rested straight after prosecution. Is that problematic? Kouri's defense got in their direct examination of Ali during the state's case, then rested straight after prosecution. Is that problematic? I don't think so. I hope I'm getting your question, the crux of your question right, but I don't think so. I think it comes down to, did they get out of Ali what they wanted to get out of her? And do they feel that they have any benefit to calling other witnesses? I mean, that's the other thing too. If you're going to put on a defense and you're going to call a witness, and you're going to call a witness for a very limited purpose, and those aren't scoring a whole bunch of points, that alone may backfire on you. The jury may be saying, what did we do here? What are we doing? That was their whole defense case. One witness with a few questions. How did that help? Whereas calling no witnesses, maybe jurors might be assuming, oh, okay, well, they don't feel that they need to. You know what I mean? You kind of open up the door for criticism when you actually start to put on your own case. So thank you for that, Jadzia. Mom of Arlo the Doxy, thank you, says defense had someone watching because she said she could get a readback of a question that Bloodworth asked. That's a very good point too. I remember that. So someone was at least watching the stream, but was someone watching it on a YouTube channel where they're watching the chat is kind of the other question there. But yeah, you're right. Somebody was watching it somewhere and kind of live transcribing it. Eroy, thank you, says Gonzalez's lawyer mentioned on Lawyer You Know interview that they were watching the YouTube to get sentiment. There you go. Fascinating time. So if you're watching these trials over on Courtroom Confidential Live Trials, that's our sister channel where you can watch all of these streamed live, be thinking about that. Your comments might be important to someone somewhere. So please join the chat and feel free to share and feel free to criticize. Maybe they'll find it helpful. All right. Buckle down, Ritter. Where are we off to next here? Here we go.
Hi, Josh and the crew. This is Freddy's cat from Berlin, Germany. I have been listening and enjoying your shows for a long time. Here's my question, which is cut over between the Lori Vallow Daybell and the Kouri Richins cases. Both of their husbands, Charles Vallow and Eric Richins, they had suspicions that their wives were up to no good, but they did not have enough evidence yet to file a police report. In their situations, how could they preserve their suspicions in a way that would later not be dismissed as hearsay? If they wrote it down, it would be considered a self-serving statement. If they told someone, it would be hearsay. I remember that even statements from Charles Vallow, taped on police body cam, could not be admitted into evidence against Lori because they were considered hearsay. Would it help to share their suspicions in a group setting so several people would hear it at the same time? Or should Charles or Eric have left a sworn affidavit with an attorney? What are your thoughts, Josh? Thanks for taking my question. Have a nice Sunday. Bye.
Freddie from Berlin, Germany. Is that our first Germany? No, we've had other Germany. Oh, there we go. Well, you guys need to get together, the two of you. Doesn't look like it's that far. Day trip, maybe, to say hi. Thank you so much, Freddie. And this is a great, great question. Freddie is asking, what do these people do? What do you do if you're Lori's husband or Kouri's husband and you're trying to preserve somehow, if I end up dead, here's who did it. What an awful situation. And Freddie brings out, and yeah, this was a very interesting situation in the Lori Daybell case where her husband, who she is now convicted of murdering, had talked to police and told them about her mental state and told them about how she's violent. And that didn't come in because it was hearsay. Hearsay, out of court statement offered for the truth of the matter asserted. So what do you do? This is really interesting. This is very interesting. All of what I'm going to tell you as far as suggestions don't necessarily solve the problem, but at least would give that person a fighting chance. And what a morbid kind of situation we're talking about here. We're obviously talking in the hypothetical, but people could keep Freddie mentions a sworn affidavit. So I guess you could go to your attorney and say, I want to put it on the record that I feel my life is being threatened by my spouse. And if anything happens to me, that's who I think did it. Again, though, that is hearsay. Recording it, a diary, a voice recording, all are hearsay because they are a prior statement, an out-of-court statement being offered for the truth of the matter asserted. You're still going to have to deal with this hearsay issue. An exception is if you're talking about your present mental or physical state. So somebody, potentially you could see an argument of where someone just had their life threatened by their spouse, calls up the police and says, I'm afraid for my life because my loved one, I believe, is threatening me. Charles Vallow, did he do that? Argument to say that he did, but the way that he was speaking, it didn't sound like he was speaking about a present condition of fear, but more about things that she had done in the past. But if somebody calls 911 and is reporting, I was just harmed by my loved one, I'm currently in pain, I'm currently suffering from a physical injury, I am in fear of my loved one, that should qualify as a present sense description of a mental or physical state, which is an exception to hearsay. To be a little bit serious about this, though, the answer is always go to the police. And I know Freddie kind of started this out with, they didn't go to the police because they didn't feel that there was enough for a crime. True. But if a person is truly in fear, they should go to the police because at least that creates a record. And a good prosecutor is going to find a way to get those prior police reports in. If that's a 1101B, prior bad acts type situation, prior acts of domestic violence type situation, they're going to get that stuff in. And that's really the way to preserve it. But again, we're talking about some morbid stuff here. The end result is always go to the police, always try to get help. Great question though, Freddie. Really, really glad that you asked that. And thank you for calling from Germany. Gina Gilmore, thank you, says Susan and Suzanne Simpson told her attorney or banker that if she was missing, to search the lakes. There you go. But again, the issue there is that's hearsay. Is there an exception to it? Doesn't appear to be, unless she was currently under, some sort of present, I'm terrified. If I end up dead, find me in the lake. You could see an argument though for the defense to say, well, the I'm terrified part, but they find me in the lake part, you can't get in. I mean, hearsay is a real doozy of an issue in many cases. Shy Gal, thank you so much. Been a member for 15 months. Says, thank you to the kindest, most intelligent, generous chat on YouTube. You all are so amazing. It is true. It's the best chat. It's the smartest, kindest, most generous chat on YouTube. Kenny G has been a member for 3 months, everybody. Does Kouri Richins realize her face... her face is on trial too? Yeah, she can't help herself, can she? She is just... she can't help herself. And her attorneys, I don't know if they've talked to her about it or not. But yeah, if the jurors are watching her as closely as all of us are, she might get convicted for that alone. Great question. All right. Keep it moving, Ritter. Here we go.
Good evening, Josh, Tiff, Kaylin, CC crew, and CC pet crew. This is Helen Skorshlama. This is not my question, but today marks 30 years since the bounds of Dunblane were slaughtered, so everything's a bit thoughtful in Scotland. The second thing is that it's Mother's Day in Scotland, in the UK this Sunday, so happy Mother's Day to all CC crew mothers and mothers with fur children. And now for my question. In a nobody homicide case, which there was a very famous one near where I grew up, a lady named Arlene Fraser, who was eventually, whose husband was eventually convicted of her murder. How do you know that it is a homicide and not, for example, that the person's gone out, been attacked by a very angry, evil swan, and the swan has not done something to them and their body's been washed away? So how do you make differences between the two? Thank you.
A murderous squadron of swans. HTSL from Edinburgh, Scotland. Always great to hear from you. Thank you so much for asking the question. And it's a great question. But first of all, you bring up a couple of things. I was not, I think I had remembered this, but I had not thought about this in a long time. So she brings up the Bairns of Dublin. This is the Dunblane, pardon me, the Bairns of Dunblane. This was the Dunblane mass shooting. Took place in 1996, March 13th. You're right. It was 30 years ago, as of 2 days ago. Really horrific. The most deadly mass shooting in British history. A man by the name of Thomas Hamilton. And for motives that are still not all that clear, entered the school, totally premeditated, brought 2 handguns with him, cut off the telephone wires, entered the school. 16 elementary school students, 16, and a teacher lost their lives. And then he took his own life. Just heartbreaking stuff. So yes, a good moment, opportunity to take an opportunity to remember that horrible tragedy. It led to what is referred to as the Snowdrop petition in the UK, where they had dramatic change in the law and strict firearms restrictions to this day. Really, really horrible stuff. Switching gears and doing almost a complete 180, though, you again remind me to say Happy Mother's Day to everybody in the UK. So Happy Mother's Day. There you go. And then now to your question about, boy, we're doing a lot of quick pivots here. mass shooting, Mother's Day, back to no body cases. Here we go. What do they do in a no body case? So you mentioned Arlene Fraser, again, a case I had not heard of. So here's the quick facts on Arlene. She goes missing on April 28th, 1998 out of Elgin, Scotland. Her husband, Nat Fraser, is suspected to be the murderer. He's actually out on bail at the time for attempted murder of guess who? Arlene. But he's got an alibi. So police don't know what to do until Nat's friend, quote unquote, Hector Dick, comes forward and testifies against him. They actually have a trial. It ends up getting overturned. He comes back for a second trial. He is not convicted for this crime until May of 2012. You guys do the math. That's a lot of years later. And it was a no body case because she was never found. So to Helen's question, though, what do you do in a no body case? How do you prove that the person wasn't just killed by some other means? This is the crux of no body cases, right? Is that there's always the problem of how do you even prove the murder to begin with? Do you know no body cases? I think the first no body case, it wasn't all that long ago. I mean, I want to say it was maybe in the past 80 years or so. I could be totally wrong on this. I should have looked that up. But I know that it's not like this. There's not jurisprudence on this, at least in the States, going back for, a couple hundred years. Like no body cases. It used to be if there was no body, people felt like you couldn't. Where's the corpus, right? Where's the corpus of the crime? How are you going to prove a murder when you don't even have the results of that crime? And that prevented many cases from being prosecuted. And then finally they said, hey, we don't feel like we actually need the body to prove a murder here. We're going to prove it circumstantially through other means. So here's the biggest problems with no body cases. First of all, how do you prove this person didn't just run away? People do that, by the way. People just disappear, decide they don't like their life. Maybe she didn't like living with Nat. Maybe she didn't like the idea that he had already come after her once, and she decided the best thing for her was just to take off, never be seen from again. Could be. That's why in these no body cases, you get a lot of evidence about the habits of the person. This is a person who never would have left their children, a person who never would have taken off, a person who loved their dog, never would have left their dog behind, never would have left without calling their mother and telling them where they were going to be. Then sometimes you get forensic evidence. You have signs of a struggle, right? You have things like blood loss. Maybe you don't have the body, but you've got evidence that some sort of crime of violence took place. Jennifer Gledhill, remember this case? No body case, can't find him, but they actually were able to find, I think it was not on the mattress, but like on the box springs, they found where she had cleaned up blood, but they were able to forensically still find traces of a large amount of blood loss on their bed. That kind of stuff. Okay. He's gone. He's disappeared. He's vanished from the face of the earth. But who lost all this blood? That could be evidence of a murder having taken place. And then signs of a cover-up, right? We've seen this plenty of times. What about somebody who goes out and buys a bunch of cleaning supplies? What about somebody who goes about and disposing of different trash cans all around the Boston area? Sound familiar, Mr. Walsh? Sound familiar, Mr. Simpson out of Brad Simpson out of Texas, driving off with a big old tarp, bunch of stuff covered by a tarp in your truck within hours of your wife going missing. So this is the kind of stuff, but it's true. It's all circumstantial. Part of the problem too is not only proving the murder, but proving the intent of the murder. What if it was accidental and this person, like a la Brian Walsh? I thought that was an argument that would have been a far stronger argument. We got into a fight. She fell fell down the stairs, and I never thought anybody would believe me, and therefore I disposed of her body. Like, how do you prove the malice and intent of the crime itself? And then you got to go back to things like, you know, the lead up to and what was going on in their lives ahead of time. But they are difficult cases, very, very difficult cases. Usually the most experienced of prosecutors are the ones assigned those. Great question, Helen, the Scottish Llama from Edinburgh, Scotland. Thank you so much for asking it. All right. Tom Water Troy has been a member for 7 months, everybody. Washington and dude. One of my dudes. Good to hear from you. Seeking Justice has been a member for an entire year. Happy birthday. Love the show, the chat, and the mods. Well, we'd love you right back, Seeking Justice. And K9 Catherine has been a member for 19 months. Love Josh's comedy routine. I hope so. I'm just sitting in a room talking to myself, talking to a computer, hoping people are listening. All right, where are we off to here?
Hi, Josh. This is Cindy Pike from Exeter, New Hampshire, land of the Phillips Exeter Academy. And my question to you is, and I love your content, by the way, in regards to, say, the Kouri Richins trial, that judge is so patient and very, very low key, in my opinion. But he probably at some point every day needs to talk to somebody about it, right? It can't be easy. So is he allowed to talk to family members or friends about what's going on? Or is there a strict protocol when it comes to these cases? Thanks.
Cindy from Exeter, New Hampshire. Great question. Let's put you on the map, first of all. Yeah, so the judge instructs the jury, don't talk about this. Don't talk about this with your fellow jurors. Don't talk about this with your family members. Don't read the newspaper. Don't look at the news. Don't do nothing. You are to think about it while you're sitting here and not even really come to a conclusion. And then the only time that you get to actually talk to anyone else about this case is when you get back into the deliberation room. But what the judge doesn't do is give those same instructions to the attorneys. And the judge doesn't give those same instructions to himself because the judges and the attorneys are not under these same restrictions. They can talk to other people about it. Judges can and do talk to other judges about their cases and about rulings and about issues. And sometimes, I'll be honest with you, I hope that they do. Because sometimes you're in front of a judge that's not as good as Judge Mrazek, and you're hoping that that judge will go call up their buddy, Judge Mrazek, and maybe ask them a question about an issue in front of them. Same with the attorneys. The attorneys read the news. We see that they even look at YouTube, and they're allowed to talk to their friends and family all about it. They're just not allowed to talk to the public about it. Even when there isn't a gag order, there are certain decorum orders about discussing the inner workings of a case, evidence that hasn't been brought out in trial yet. Usually that's kind of a standing order, or the judge might make it even more strict with a gag order. But yeah, judges can talk to their spouses, their loved ones, anybody. They will tell you, though, I know some judges, and they are reluctant to do that. Judges are very concerned with doing anything that might come back to haunt them and be inappropriate. So most times most friends of mine who are judges, and you ask them about a case that's currently going on, they'll be like, talk to me about it when it's over. They don't want to kind of get into it right now. They're worried about somehow something getting out that they made some comment about the case. Great question, though. Cindy from Exeter, New Hampshire. Appreciate you asking. All right. Where are we off to here?
Hi everyone, it's Becky B here in Belfast, Northern Ireland. Just a quick message because, as you all know, I hate my accent awful. Anyway, I'm just hopping on to say Happy Mother's Day to absolutely all of the mothers out there. And I hope you all have a fabulous Sunday fun day. I might not be on because I will be celebrating with Mama B and my crew here, but I will definitely be on the replay for the Courtroom Confidential crew. and I will see you soon. Bye.
Becky B from Belfast, Ireland, put you on the map. Becky, let me say this. First of all, happy Mother's Day. I hope you're having a wonderful Mother's Day. I hope your mother is having a wonderful Mother's Day. Happy Mother's Day to everybody in the UK. I hope that you do watch this on replay, because I want you to know I absolutely love your accent. So I love hearing from you. So please call as much as you possibly can and ask questions. Always love hearing from you. And IGG loves your accent. And Cheryl B loves hearing from you too. So appreciate you, Becky B. Have a great Sunday, and maybe we'll see you next week. All right. Where are we at here? You guys having fun? Are we getting, I know we're going through this a little faster than we usually do, but we've got a lot of great questions. We've been all over the world. Germany, wait a minute, Germany, Sweden, Marshall Islands, Bolivar, Ohio, Bellevue, Washington. We've talked about Kouri Richins, Colin Gray, Lincoln Lawyer. Got it all covered here today. Happy Mother's Day. We're having a great time, everybody. Having a great time. Full-throated motion is 76% juiced. That means I'm going to let her retake the test. Therapist, fails the class, 50% juiced. Has to come back again next semester to retake Juiced 101. Unfortunate. I had high hopes. Therapist, says 52 more likes until we hit 800. Is that true? Well, then, everybody hit that like button. Kaylin is 10% juiced. Kaylin, I couldn't be more disappointed. I'm physically hurting from this, Kaylin. 10% juiced? That's like no juice. Jay Lee says, I love your channel and I'm a newbie. Well, you're not anymore, Jay Lee. Good to see you. All right. Hush up, Ritter, and get to it. Where are we? We just heard from Becky B. Okay, here we go.
Hey, Josh, this is Jonna from North Carolina. Today I was watching the jury instructions that was going on between the judge and the prosecuting and defense attorneys. And I had no idea that they did this before it went to the jury. I was wondering, is it always like that? I thought the judge would do it himself and read the jury instructions to the jury without the input of the two attorneys. I guess it's something that I just didn't understand, and I never knew that. Let me know your take on that and what you've experienced. And is that always the way for just a murder trial or other trials too? Thanks.
Jonna from North Carolina, thank you so much. Let's put you on the map. Great question too. Yes, the Kouri Richins trial just did their jury instructions. Closing arguments are going to be tomorrow on Monday. And Jonna wants to know, is this always a thing where they're kind of having discussions about jury instructions, or is it just that the judge hands them down? No, it's a thing. Now, in some cases, it's relatively straightforward. I've had many, many trials where nobody is in disagreement about the instructions. We all kind of submit our proposed list ahead of time. We agree on 90% of it. Maybe the judge sets aside 20 minutes for us to go through it, and we discuss those other, they're asking for this instruction. I don't know if that applies. The judge says, yeah, I think it applies, or no, it doesn't apply, and we move on. In other cases, though, this is perhaps maybe the most important stuff. What are they going to be instructed on? Are they going to hear about first degree, second degree, manslaughter? Do those apply here? Does the judge feel that certain instructions should be given that the parties might not be asking for? Does the judge have what we call a sua sponte duty to be instructing on some of these things? It can become incredibly contentious. It can become incredibly important. It's not even, a lot of it has to do with, yes, you want the jury instructed. You want to be able to argue things. If there's not an instruction on something, sometimes that limits what you can argue on. So that's an important reason for it too. But the number one appealable issue is jury instructions. Did you know that? What were they instructed on? Were they improperly instructed? Were they not instructed on something? Were they instructed on something they shouldn't have been instructed on? Were the instructions as drafted inaccurate? That's why jury instructions are so written in such a way that it sounds so arcane, because there's so much litigation about what those exact words should be, because the number one issue on appeal is jury instructions and how were they properly instructed. So yes, it is a very important part of the entire process, and some might even argue the most important part of the process. All right. Oh boy. Time for the Kleenex, everybody. We are down to the final three. K9 Catherine, thank you so much for supporting the mods with coffees. Appreciate you. Susan Riley has been a member for 1 month, everybody. Let's get some beach towels or beach blankets. I want to display and help get some more subscribers when we go to our shore home. Love the CC fam. Oh, that's not a bad idea. We could get beach towels. I would love a CC beach towel. Okay, summertime's coming up. Ladies, you heard. And Hoosier Steph has been a member for 10 months. Everybody says, happy Sunday. Happy Sunday right back at you. All right, here we go. Final three.
Hi, y'all. Court Dog Daniel here from New Britain, Connecticut. Josh, a broader question this week about something many of us who follow trials closely have probably noticed. In the true crime world, we often focus on the evidence and the legal strategy, but watching so many trials unfold, it's striking how much the human element seems to shape outcomes. The credibility of witnesses, the tone that's set by a judge, or even the personalities of the lawyers involved. From your years in the courtroom, how much do those human factors actually influence the direction of a trial compared to the hard evidence itself? And was there ever a case where the human element, like a witness, a lawyer, or even a judge, really changed the trajectory of the trial for you? I'll speak for all of us out here who love your war stories, so give us one if you got it, all right? 75 days till Crime Con. Juiced!
I can't get through it without laughing. CDD, one of my dudes. Court Dog Daniel from New Britain, Connecticut. Thank you so much for asking the question. How much does the human factor affect cases beyond just the facts? Tremendously. Obviously, the facts are paramount. Obviously, I don't care what kind of characters you've got. If you've got a tremendous amount of evidence, you're going to get a conviction. If you've got zero evidence, I don't care how good the prosecutor is, you're probably not going to get a conviction. Facts, evidence, that's the key. That's king. But the personality sure can affect it, for sure. Good attorneys, bad attorneys, good judges, bad judges probably more than anything. You wanted a war story. I will give you a war story. I had a trial. I've talked about this before. It was regarding a firefighter and regarding a lady feeding cats. And I've told this story on one of our members' lives, and I'll tell it more in depth on a member's live again if you guys want to hear it. But it's the firefighter cat lady story. And the first trial that I had on this was in front of a judge. I'm not going to name names, but I don't care if he's watching. He was awful. And he made me fight for everything, every step of the way, to the point that I was just exasperated every day in court. And I don't get it. He was just so friendly to the defense on everything. I remember at one point, over stupid stuff, the defense attorney wanted to refer to the jurors by their first name. And I'm like, whoa, we never do that. And the judge is like, well, why not? I think that's a great idea. And it was like every little thing I had to argue about and fight about. and it made for a miserable trial, and it made for a difficult trial, and that trial hung. It was caught on videotape, everybody, in 4K. The crime itself hung. Now, it hung, I think, 10-2 or something. It was not, I mean, 10-2 in favor of guilt. Retried him, got a different judge, a much more balanced judge, a much more fair judge, much more straightforward judge. I also changed the way I did the trial. I dismissed one of the defendants. At first, it was both the firefighter and his mom. I dismissed the mom, kind of streamlined my case a little bit, and got a conviction out of it. And it was it was night and day trial. And the judge reconsidered all sorts of rulings, gave me better rulings, gave me more. It wasn't just about better. It was just more in line with the law. So yes, personalities can have a huge effect on a case. Thank you for that, Court Dog Daniel from New Britain, Connecticut, who is juiced. All right. Eroy, thank you so much for supporting the mods with coffees. Appreciate you. And Potter, yes, cruise in October. Need a towel. See, the towels, ladies. We need to work on this thing. Stat, towels. Misconduct has been a member for 8 months. Misrepresentation of Nestor's statements. Lies. Not sure. I'm a little lost. Sorry about that, misconduct. All right, let's keep it rolling here. Who is going to bring us home?
Hi, Josh. This is Carol in Ongatarongai, Kenya. And as you know, I'm the president of the East Africa Courtroom Confidential Crew. And at our last meeting, we were discussing this Kouri Richins case, and we're kind of all decided that she intended to kill her husband. And she intended to kill him by overdosing him on some kind of drugs. She tried the first time in February on Valentine's Day and failed. And so she asked for something stronger. Maybe she didn't ask specifically for fentanyl, but she asked for something stronger. And Carmen asked Ronnie or Robbie or whatever his name is for something stronger. Maybe she didn't ask for fentanyl, but she asked for something stronger. And Robbie or Ronnie or whatever his name is, he got something stronger. And maybe he didn't even know it was fentanyl. And maybe Carmen didn't even know it was fentanyl. And maybe Kouri didn't even know it was fentanyl. But the intent was to kill her husband. So is that enough? Do we have to prove that she wanted fentanyl specifically?
Carol, oh, I love this question. Carol from Ongatarongai, Kenya. This has got to be the most geographically diverse show that we've ever had, I think, right? We've done Marshall Islands, Kenya, Germany, Sweden, Ireland. We're all over the place, everybody. Stubbornly, though, Argentina refuses to leave us a message. And Brazil and Chile. I'm talking to you folks down there. But look at this. Incredible. Just blows my mind. Blows my mind. Thank you so much, Carol, who is the president of the East African Courtroom Confidential Fan Club. So thank you for that, Carol, for all the hard work that you do. And this is a great question. I love this question. I hope you talking about them monitoring YouTube. I hope the prosecution is monitoring this chat today and heard what you said, Carol, because I think that is such an important point here. The defense would love for this whole case to be about they can't put fentanyl in Kouri's hands. They've said as much. The defense would love, in fact, Nestor even said, this case is about, did he have a drug problem? And if he did, my client's not guilty. What? No, it's not. Those things are not mutually exclusive. He could have had a huge drug problem and she still killed him. And she could have been buying drugs from all sorts of different people and still killed them with fentanyl. The defense would love that the prosecution had the added burden of proving that she knew she was buying fentanyl. Everybody knew they were selling fentanyl. And in fact, this is how she got the fentanyl. We don't need to know how she got the fentanyl. We need to know she put the fentanyl in his drink. We don't even need to know that she knew it was fentanyl. We just need to know that she put something in his drink and she intended to kill the guy. That's all we need to know. So your points are incredibly well taken. Does it matter that Carmen knew it was fentanyl? She was asking for stronger stuff. Does it matter that Rob knew he was selling fentanyl? She was asking for stronger stuff. That's all that matters is her intent. Did she know it was fentanyl? Who cares? She knew she got something stronger and she put it in his drink. Okay? She intended to kill the man. That's all that we need to know. That's all they need to prove, I should say. That's the question. If you feel they proved that beyond a reasonable doubt, then you vote guilty. If you feel that they haven't proved beyond a reasonable doubt that she knew it was fentanyl, you don't need to even worry about that. Great question, Carol from Angata-Rungai, Kenya. I just love saying that. All right. Who's bringing us home here? Last one. God, I've got good timing. Look at this timing, Tiffany. You like this? Okay. All right. Last question. And then we got some announcements. So don't go any, even before we even play this, I'm going to tell you, I'm watching. Don't go anywhere. We've got some announcements for you I want you guys to hear about. All right. Who's bringing us home?
Hello, Ritter family and the CC crew. This is CCB calling from the DFW area, which is Dallas-Fort Worth in Texas. I'm calling to let Josh know that, sorry, but the motion to deny pajamas in airports has been denied by the court. There's no case law to support it. I'm sorry. But to get to my question, could you explain the process that has to happen to go from being a suspect to going to trial? I think a lot of people aren't familiar with the process, and I think it'd be helpful for everybody to know all of the steps that happen between an investigation and somebody being arrested and indicted and then having to go to trial. That's all. Thank you. And I appreciate you. By the way, I have resubscribed now that I can afford it. And the reason I did it is because you're the only objective courtroom coverage. And I appreciate you. Thank you. Have a great day. Bye.
Oh, Cece, that touches me. Thank you very much. I appreciate that. Cece from Dallas-Fort Worth, Texas, putting you on the map. Great question. How does it go from suspect to defendant? How does that all work? Well, it all comes down to probable cause, or if you're in the know, if you're in the biz, you just call it PC. What's the level of PC? So this is a huge part of criminal law. This is probably one of the most kind of discussed issues when it comes to evidence is PC. And it, at varying levels of probable cause, allows the police to do different things. So let's start from the lowest. Either based on mere suspicion or not, you have what's called a consensual encounter. So police are free to walk up to anybody and say, "Hey, how you doing today? I see that you're standing outside of this this bank before opening hours. Everything okay?" That's not really based on anything, any kind of level of suspicion. Maybe you call it a hunch, but as long as that encounter is consensual, they're allowed to do that. Police are allowed to go talk to you like you're allowed to talk to anybody, but that person is allowed to say, "I got nothing to say. Keep it walking, copper. I got nothing to say to you." That is called a consensual encounter. Next level up is reasonable suspicion. This allows for the police to do what's called a stop, a Terry stop, an investigative stop. They have to have some sort of articulable facts, though. Something about this person. The guy standing in front of the bank was holding a ski mask in his hand, wearing gloves, and had a bag in the other. There's articulable facts that raise to the level of a reasonable suspicion that something may be happening. Then police can go conduct a Terry stop. Where does the word Terry come from? From case law, like we talked about earlier. Terry v. Ohio. Somebody named Terry somewhere along the line got stopped by police, had a question about it, thought it was wrong. We had to discuss what is probable cause and reasonable suspicion, and now we've got case law, and we call it a Terry stop. Like I said, it's a temporary investigative stop. It's also what we refer to as a stop and frisk. You're allowed to stop the person, pat them down for officer safety. A lot of case law surrounding this too. What is a pat down? Where are they allowed to put their hands inside of a pocket or just on the outside of a pocket? What are they allowed to do if they feel something? There's actually a concept called, you know, how something is in plain view gives police probable cause to do something. There's also something called plain feel. If you pat somebody's pocket and you in plain feel a handgun, that gives you further probable cause to reach inside the pocket to pull out the handgun. Again, it's all about probable cause. Then the next level is called probable cause, just to further confuse us. But this is the idea of the fair probability of criminal activity. So now it's beyond a reasonable suspicion. We're not just curious. We don't just have a hunch. We're not just reasonably suspicious. Now we have probable cause. Now that guy outside of the bank, there's an alarm going off, right? And they're holding a bag with a big old dollar sign on it. That is, you haven't seen the crime. You didn't eyewitness it, but you have probable cause that there's a fair probability that that person committed a crime. Now you have probable cause to make an arrest. And there's where the police stop. Now they've made an arrest. Now they got to bring it to the DA's office. And the DA's office has to decide, does this satisfy my filing standards? Do I have evidence beyond a reasonable doubt that this crime was committed by this person? And that should be the filing standard, beyond a reasonable doubt, that this person, I can convict this person at a jury trial. Therefore, I'm going to file criminal charges against them. And now they become a defendant. So that's how you go from a suspect to a defendant. Hope that made sense to everybody. Great question, CC, from Dallas, Fort Worth. Gossip and rumors in the chat, everybody. What if it's not a handgun and they're just happy to see? Quit it. Stop that. Stop that right now. This is a family show. Gossip and rumor. All right, everybody. Like I said, don't go anywhere. Let me give you some quick announcements. First of all, let me tell you about a website. It's called thecourtroomconfidential.com. On that website, you will find the following things, the 3 M's, as I refer to them. First of all, if you loved the messages today, but you're thinking to yourself, I had a question, I want to ask a question, you can go to thecourtroomconfidential.com and click on send us a message, and that's how you can ask a question for next week. Membership. A lot of folks joined up today. A lot of folks received gift memberships today. Grateful for all of that. But if you missed out and you still want to become a member, we would love to have you. Click on Become a Member, and that's where you can find out about all of the benefits of membership, and there are lots. Dr. Von K, thank you so much for your generosity. Right back at you. And then finally, merch. If you want a t-shirt like this, or you want any of the other colors that we have available, and it's not just t-shirts, by the way. We've got hoodies, we've got zip-ups, we've got quarter zips, we've got mugs, we've got pajama pants that you can wear to the airport, we've got tumblers, we've got hats, and soon we will have beach towels, so I'm told. 60 more likes to 1,000. Let's go, everybody. So that's the shop at thecourtroomconfidential.com. Then what did you miss this week? Well, first of all, on Friday, we had our weekly roundup right here on this channel. We talked about Kouri Richins, Jaden Wallace. This is the young man that ran over his teacher. Really tragic case out of Georgia, I think it was, and Lincoln Snelling. So please check out all of our latest coverage on your weekly roundup on the channel right now. Oh, thank you for the ad-free stream, says Therapist. I never bring this up, but yeah, we have dedicated ourselves to every time we're live, we're going to do it without ads. So we appreciate all the support that you guys help us to supplement all of that. Thank you, Therapist. I love Sunday Fun Days. I love Sunday Fun Days, says Ms. Brown Eyes. And then the weekly rap sheet, not to be confused, on Fox Nation. This is a show I co-host alongside Paul Morrow and Donna Rotuno. We had our latest episode, really fun for that too. I was in Utah where we happened to do that one live. We talked about Tyler Robinson, Kouri Richins, a lot of great stuff. So please go check those two things out. Then stay tuned. As I said, tomorrow, Monday, on Courtroom Confidential Live Trials. That's our sister channel where we stream all the trials. We're going to be having closing arguments in the Kouri Richins case. Don't miss it. Come to the Cool Kids table and watch it with us starting at 7:30 a.m. Pacific, 10:30 Eastern. And then after that, we'll be on Verdict Watch. So should be exciting stuff. Kouri Richins tomorrow. Also, tomorrow, I am going to be going live that evening. We might even be talking about a verdict, but we'll certainly be talking about closing arguments, along with Kathy from Gossip, Rumor, and Innuendo. She'll be discussing the latest on the Kouri Richins closing arguments with us, or maybe even a verdict. So please check that out Monday night. Wednesday, we're going to be back here for our Wednesday night live. That'll be at 5 a.m. Pardon me. Monday's at 5 p.m. Wednesday's also at 5 p.m., 8 p.m. Eastern. That will be on, we're figuring out a guest on that one. So TBD. And then right now, I'm 2 minutes late. I'm going to join them a little bit late. True Crime with Sarge. Head over there right after this. They've already started. I'm going to join them. We're going to be talking about, I think Rex Heuermann, maybe Nancy Guthrie, a lot of stuff. So I'm going to jump on there as soon as I'm done here. But Full Throated Motion just gifted a membership. I'm not going to stop without mentioning that. And I'm going to mention one last announcement, and that is CrimeCon is coming up May 29th through 31st in Vegas, baby. Two things. One, 10% discount if you enter the word courtroom, all in caps, all one word, at checkout. And we've got an exclusive shirt. I showed it to you already, but I'm going to show it to you again because I'm so proud of it. It says, "Let's keep it rolling." It's co-branded with CrimeCon and Courtroom Confidential. It's exclusive to this CrimeCon, but we're going to go ahead and release it to all of our members early. So starting April 1st, we're going to send out a code for you guys to be able to purchase this brand new shirt that we're very proud of. We received a couple of samples and I love it. I'm very happy with it. Very proud of it. Big thank you to Afton, Sonia, Kathy, and Therapist for being our mods. If you haven't heard, now I'm going to tell you, they are the best on YouTube. So thank you so much to all of them. Big thank you to Kaylin for all the hard work. Get those numbers up, Kaylin. Those juice numbers are not acceptable. Get them up. Get them up. And to Tiffany, who is the best thing that ever happened to me. Take care, everybody. We will see you all soon. Take care. Bye-bye.